What's up, YouTube? It's your boy Maverick Raven coming at you with another video. And it's happened, you guys. It's happened. The Supreme Court has just let down their opinion, their ruling. And they say that Donald Trump and presidents, and obviously not specifically Donald Trump necessarily, but presidents do enjoy immunity from prosecution for official acts. It was a 6-3 decision. It doesn't take a genius to figure out who the three dissenting were, but thankfully we have a majority of conservatives. So that's always good. So we're gonna get into this. Don't forget to like, comment, share, and subscribe. We'd love to have you as members of the flock. The flock is for life. And come on, come fly with us. We'd love to have you. The air is for everyone. Now, it says the Supreme Court rules Trump has some immunity in federal election case. Now, this is it's gonna kind of destroy the Democrats' case in a lot of places, especially in the I bet you, especially in the confidential documents case, the ones that he didn't declassify these. Do me a favor, bro. Anyways, the Supreme Court ruled 6-3 that presidents enjoy immunity from criminal prosecution for official but not unofficial acts in a decision that's expected to delay former President Donald Trump's trial in the federal election case in Washington. The Supreme Court held that under our constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within his conclusive and preclusive constitutional authority, and he is entitled to at least presumptive immunity from prosecution for all his official acts. There is no immunity for unofficial acts. This came through today. This is breaking news. It says the July 1st decision remands the case to the district court for further consideration. Chief Justice John Roberts penned the majority opinion, which is amazing because he's like a rhino, but obviously with a justice robe on, because he's not really a conservative, bro. He's not. He comes back and forth as the tide shifts. It's crazy. It was joined in full by Justices Clarence Thomas, Samuel Alito, Neil Gorsuch, and Brett Kavanaugh. Justice Amy Coney Barrett joined part of the opinion while issuing a concurrence of her own. That's interesting. Justice Sonia Sotomayor penned a dissent, of course, which was joined by Justice Ketanji Brown Jackson, who doesn't know what a woman is, and Elena Kagan. Justice Jackson also issued a dissent. Ugh, gosh, what a waste of life. Former President Trump responded to a decision on Truth Social. Big win for our Constitution and democracy. Proud to be an American. Yeah. This doesn't make up for the witch hunt, though. This doesn't make up for the witch hunt. The ruling is a partial win for former President Trump, who asked for a broader form of immunity than the justices ultimately granted. Former President Trump had asked the court to rule that he enjoyed immunity from criminal prosecution for his official acts unless Congress had impeached and convicted him for those acts. I agree with that. Of course, it doesn't matter because the Supreme Court put forth their judgment. So, but anyways, this DC District Judge Tanya Chutkin had rejected the idea that presidents enjoyed immunity from criminal prosecution, as did the U.S. Court of Appeals for the D.C. Circuit. During oral argument in April, the conservative justices seemed poised to remand the case back to a district case in Washington with instructions on what constitutes official and private acts for further fact-finding proceedings. We're writing a rule for the ages, Justice Neil Gorsuch said during an oral argument. He and Justice Ketanji Brown Jackson both made clear they were concerned about cases beyond former President Trump's, which has forced the court to grapple with what constitutes a president's official conduct. Attorney John Sauer argued for former President Trump, and former Deputy Solicitor General Michael Dreeben argued for Special Counsel Jack Smith. Oh, Lord. Just seeing his name is like, ugh. The most recent time the Supreme Court issued a major ruling on presidential immunity was in 1982 in Nixon versus Fitzgerald. The court ruled that presidents enjoyed absolute immunity from civil liability for actions that fell within the outer perimeter of their official duties. So what's next? The Supreme Court remanded the case or sent it back to the D.C. District Court for further consideration. More specifically, excuse me, the justices directed the district court to assess in the first instance whether a prosecution involving Trump's alleged attempts to influence the vice president's oversight of the certification proceedings would pose any dangers of intrusion on the authority and functions of the executive branch. Another aspect of the decision directed the district court to weigh whether various aspects of Mr. Smith's indictment constituted official or unofficial acts. That include allegations that former President Trump's attempted to sway state officials, use fraudulent slates of electors, and his communications on January 6, 2021. Oh, Lord. Well, you guys get it. It's going to go back to the district court. It says, on remand, the district court must carefully analyze the indictment's remaining allegations to determine whether they too involve conduct for which a president must be immune from prosecution, the Supreme Court said. And, you know, this isn't over because the leftists are going to do what they do, you know. And it's probably going to end up going back to the Supreme Court if I wasn't, you know, if I was a betting man. I'd say that eventually, in a couple of years maybe, it'll be back in front of the Supreme Court. Because the district court, they're a liberal. That specific district is known for being liberal. So that's it for this video, you guys. Because this is all very dry stuff that you guys, I'm sure, don't even care about, you know. But yeah, it says if necessary, the district court should determine the first instance whether the section 1512C2 charges may proceed in light of our decision in Fisher. So yeah, so so this is going to be interesting because just a few days ago, Fisher versus the United States vacated the D.C. court's interpretation of a statute the Justice Department used to pursue January 6 defendants and President Trump. So that's going to be interesting. It's going to be very interesting. And in a footnote, Justice Roberts said that if necessary, the district court should determine the first instance whether the blah, blah, blah charges may proceed in light of our decision in Fisher. So yeah, so that's kind of interesting. But that's the video, you guys. You know that I love you. Thank you very much for staying here with me. For now, though, you guys stay safe and stay based.